House Civil Law Committee will come to order. Can I get a motion on the minutes? Minutes have been moved. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you. First bill up is House File 1112, and Representative Winkler is not here yet, but Burt Black is here. Mr. Black, would you be willing to begin comments on the bill, and we can finish up when Representative Winkler gets here.
Yes, thank you, Mr. Chairman, and good morning, members. My name is Burt Black. I'm the legal advisor for the Office of the Secretary of State. And House File 1112 is every couple of years we're here with a smorgasbord of suggestions for improvement in the business entity and lien filing laws, and this year is no exception. And I can tell you that there are 10 sections here, 10 mighty sections. We're trying to harmonize, conform, clarify, streamline, and otherwise improve our business entities law. I can also tell you that we have shared this text with the business law section of the State Bar and with the cooperative network, and we have heard no objections, and they've had it for well over a month. There are 3 sections here which address the question of data practices, and I would like to go over those first. The other 7 sections those are the exciting sections in this bill, Mr. Chairman.
We're not interested in anything exciting here, Mr. Black. This is the Civil Law Committee.
Right. Section 1 is an amendment to a law that we worked on with Representative Holberg in 2009. And it allows us to use email addresses that businesses give us to provide their official notices. At the time, we were only doing paper filings, and so it only addresses paper submissions. The law allows the customer to keep their email address as non-public for bulk data sales if they check a box. We now have digital equivalents of that, and so we'd like to extend that to the digitally created documents. And then there's some clarifying language that indicates that if you ask for the information of a particular company, so if you ask for the filings for ABC Corporation, and that's on there, that will be given to you. The theory being that if you have if you're asking for those copies, you probably need to get a hold of that company. Sections 9 and 10, and by the way, there is a bill summary in your packet. Also in your packet are some materials that address sections 9 and 10, which are the other data practices issues. And these are 2 forms, one old, one new, that are used for Uniform Commercial Code financing statements. In 2010, we came to you and asked that the Social Security number and the taxpayer identification number, which had previously been public in our hands, and that was sort of a non-conforming use for the Social Security number, that they be made private. The Social Security number is still going to be private. We asked for the taxpayer identification number to be made private at that time because on the old form, if you look at box 1D, that is the box where both the SSN and the TIN were placed. And it just seemed like a good idea at the time to just not have to try to interpret which is which because they're both 9-digit numbers. In 2011, the Uniform Law Commissioners came out with a number of changes in Article 9, which the legislature enacted and which will go into effect this July 1st. One of the changes, if you look at the new form, is that the SSN and the taxpayer information number field is gone. We don't want that information. We never really have wanted that information. but it's gone. And so the taxpayer identification number, frankly, it's all over the place. It's on your W-2. It's on the 990s. It's the IRS sells it, and you can get it online for a nominal fee, of course. And so we'd like that to be made go back to its previous status of public, because frankly, that would streamline the provision of UCC copies greatly. The other sections of the bill, Mr. Chairman and members, let's go back to chronological order. Section 2 changes
Mr. Black,
Yeah.
are these the non-data sections?
These are the non-data sections.
Okay, well, I don't think we're interested in going through
Okay.
all of those.
You've got the bill summary, and
Yeah.
they're all kind of boring.
Okay, are questions from members of the committee? Seeing none, then Representative Winkler moves that House File 1112 be recommended to pass and sent to the General Register. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you, Mr. Black, for your testimony. Welcome, Representative Winkler. Are you prepared on House File 283?
I am, Mr. Chair. I would recommend it to pass and be re-referred to
General Register.
the General Register.
And you have an A13 amendment, Representative Winkler?
That is correct, Mr. Chair. And
Do you have
I would
any
move the
testifiers?
A13.
On this, Representative Winkler?
No, I move the A13 amendment.
Okay, Representative Winkler moves the A13 amendment in order to get the bill in the shape the author desires. All in favor signify by saying aye.
Aye.
All opposed say no. Motion passes. Okay, Representative Winkler, to your bill as amended.
Mr. Chair, members, there is a very basic rule of evidence that says if the parties are agreeing to mediate or try to settle their dispute without the involvement of the court directly, any information they share with each other should not be admissible in court later to be used against them. It's a rule that allows, or that is designed to encourage parties to settle and not use up court time. House File 283 basically just expands that rule a little bit to a collaborative law process, which is basically it's a dispute resolution method that was put together by the Uniform Laws Commission. So this is a fairly straightforward, simple expansion of the concept of that privilege.
Thank you, Representative Winkler. Do you have any testifiers?
No, Mr. Chair.
Are there questions first from members before I take, well, why don't we do, is there anyone in the audience who would like to testify either in favor or in opposition to House File 283? Questions from members of the committee? Okay, then Representative Winkler has moved that House File 283 be recommended to pass and sent to the General Register as amended. All in favor signify by saying aye. Aye. All opposed say no.
No.
Motion passes.
Gee whiz.
Representative Winkler, to your next, do you have another, where's our calendar here? You have House File 1058. Are you prepared on that, Representative Winkler?
Thank you, Mr. Chair. I recommend that House File 1058, or I move that House File 1058 be recommended to pass and be re-referred to the Committee on K-12 Education Finance.
Okay, Representative Winkler moves that House File 1058 be recommended to pass. Did you say Education Finance, Representative Winkler?
That's correct.
Okay. And you don't have any amendments, so we don't have any amendments pre-filed. So to your bill, Representative Winkler.
Mr. Chair, members, this is the Early Childhood Scholarships Bill, the Many Minds Bill, that has been put together with a host of advocates and people who are focused on improving the learning opportunities for Minnesota's youngest children and its at-risk children. This bill passed out of the Early Childhood Policy Committee unanimously. And there are just a couple of provisions that relate to data, and that's the reason for the stop here. I would direct your attention to lines 3.19 to 3.21, which requires a child who receives a scholarship for an early childhood program to complete their development screening, which is required for all children. And basically, the reason this is a data issue is that when that screening is completed, the child is assigned a MARS number that the Department of Education uses to track students. So it's basically putting that in place for now. If students don't get this at their screening, they will get it when they become kindergartners anyway. And so the idea here is that you create more accountability for these early childhood programs by assigning a MARS number when they are starting out in this program. I would also then refer you to page 4, lines 4.7 to 4.14, which is subdivision 11. And this relates to data that is collected by the director of the Office of Early Learning pursuant to this program. The families have to fill out an application which contains some basic information about the child, and this allows the director of the Office of Early Learning, which is at the Department of Education, to basically aggregate some of that data. And it also, this paragraph contains language requiring any of the early childhood providers to keep data that they collect confidential, and mirrors language in the Data Practices Act. That is the reason why this bill is here, and I would ask for your support.
Thank you, Representative Winkler. Do you have any other testifiers to your bill? Are there members of the audience who wish to be heard on House File 1058? Questions from members? Representative Holberg.
Thank you, Mr. Chair and Representative Winkler. We have lots of current law around student records, et cetera. What elements of data are you collecting that aren't already classified under current law?
Representative Winkler.
Mr. Chair, Representative Holberg, if you go to page 2.36 and then just over to the next line, 3.1, the language says that the director may prioritize applications on factors including family income, geographic location, and the needs of the child. That is the kind of information that will be collected. And it may be that the language in 4.10 that says that it's private, as pursuant to the Data Practices Act, that middle section of that paragraph may be extraneous, but the other language about the provider needing to hold that information confidential, that is not currently in the Data Practices Act as applied to those individual, or as opposed to as applied to those providers. So I think that language is necessary. But otherwise, I don't think this information gathering is so different from what we would gather in any other educational context.
Representative Holberg.
Mr. Chair, I'm not sure what it means, must treat the identification numbers in a confidential manner. I mean, we usually just classify data, and if it was classified as confidential, it wouldn't be available to the participant. And I don't know what you're saying there. I mean, I think we just want them to follow the law. And so I don't know if that's just confusing, because I don't know what a confidential manner is under Chapter 13.
Representative Winkler.
Mr. Chair, Representative Holberg, I think the issue is that the participating program is not necessarily a public program. These could be family home-based child care programs that are licensed. It could be, the YMCA. It could be a church-based program. So these aren't public entities who are collecting the information from the families. And so that's why, and I think Mr. Guerin can speak to this. This section, at least, was, I didn't discuss it directly, but he discussed it with one of the advocates, that this language applying these standards to the private sector providers is probably a good idea and would not necessarily be captured under the Data Practices Act. If you have a different opinion about that, I'd be more than happy to fix that up.
Representative Holberg.
Well, Mr. Chair, I'd be interested to see what Mr. Guerin says, but it's kind of, in some ways, going back to the library issue, that I'm guessing there's going to be some type of contract between the government entity and the providers, whether they be private entities or not, and would thus be subject to Chapter 13 provisions. So,
Well,
Mr. Guerin, why don't you...
Mr.
Winkler.
I'd just like to address the question of the contract. I'm not, Mr. Chair, Representative Holberg, I'm not certain that there actually would be a contract. The way this program works is that to be eligible, the programs have to be rated based on quality, and then the scholarship basically goes to tracks the child, but the state makes the payment directly to the provider based on whether the child is there. So I'm not sure that there actually is going to be a contractual relationship. It's not like a human services provider where they are contracting out state services. So I'm not sure that there actually would be a contract.
Representative Holberg or Mr. Guerin.
Mr. Chair, Representative Holberg, that the way Representative Winkler described it is the way I understood it from talking with the advocates yesterday, that the participating program providers may or may not be a public school, and there will be private schools involved as well, and there's not a contract in the way that the Data Practices Act kind of contemplates a contract between a government entity and a private program. So some language about how those programs have to classify and handle the data is probably appropriate in the bill. Whether or not it's written the right way is kind of a policy choice, but there probably should be something in there.
Representative
And,
Holberg?
Mr. Chair, just to be clear then, is your intent of that language, treat the student identification numbers in a confidential manner, that they treat them in a manner as dictated by Chapter 13?
Representative Winkler.
Mr. Chair, Representative Holberg, that would be my intention, that the providers would have to follow the same standards for data privacy that a public entity would.
And so, if I might,
Representative Holberg.
Mr. Chair, it's not your intent that you're classifying the data as confidential. In other words, the providers could give information to individuals about themselves that's held in the record.
Representative Winkler.
Mr. Chair, Representative Holberg, yes, I would expect so. And I don't think this is going to be information that the individuals wouldn't know themselves, like where they live and what their family income is and things like that.
Representative Holberg.
Well, again, Mr. Chair, words matter, and I'm just trying to figure out what you're trying to do here.
Yeah.
Thank you.
Thank you, Representative Holberg. Other questions from members? Representative Howe.
Thank you, Mr. Chair. And you probably covered this, but I just enlighten me out of ignorance. So it being that we're not dealing with public institutions, we're dealing with a lot of family providers and different providers. What happens to that data once that NP, because I know that there's a lot of folks that come into this field and go out of this field. Is there any instructions or any restrictions on what happens to that data after they go out of business? Where does that data go? How is that data handled?
Representative Winkler.
Well, Mr. Chair, Representative Howe, I can't actually answer in all cases what they're going to do with it. The obligation of keeping it confidential would suggest that they have to destroy it or return it to some other entity without using it or dispersing it to somebody else. I mean, that's the basic concept. It's not supposed to get in someone else's hands. And so the obligation to treat it in a confidential manner is not unlike lots of other information those child care providers are going to collect on all sorts of kids who come into their program. But, whether it's CCAP funds or just private pay, they're collecting information. And there is an obligation to keep that information from being spread to the neighborhood.
Representative Howe.
Thank you, Mr. Chair. And I guess my concern is if we needed additional language because it's not a public institution, should we not put something in there to guide those folks or to reference that because it's not a public institution? And I just got concerns that data is not going to be held as we intend it to be held, and that's my concern because we are dealing with family practitioners.
Representative Winkler.
Mr. Chair, Representative Howe, child care and preschool programs is a major industry in the state. People come in and out of it all the time. They handle medical information. They handle all sorts of things that are far more confidential in nature than the kind of data we're anticipating in these applications. So you may, and I don't have an answer for how the industry regulates its own confidential data, except that the language in 4.13 to 4.14 does at least put legal responsibility on the provider to ensure that the information is not released. And frankly, if you have a child, as I do, in a private preschool program at our church, and we're providing medical information, releases, all sorts of things to them, and I don't ever recall signing a confidentiality agreement of any kind with them. So my presumption is that this is an issue that is already dealt with in the industry and probably by regulation similar to the language here. But at least this language is here requiring that these program participants keep it confidential.
Representative Howe.
Thank you, Mr. Chair. And I'll go back to a comment that I made in another committee, is that my concern is on that same part that you brought up on 4.13 and 4.14, is that indicates that the participant provider is liable for that damages resulting from improper release of student identification number under this subsection. My concern is that they're not the only ones with that student identification number, yet you're holding them liable. And as we've had discussions in other committees about other bills, that he who does the crime or releases the information should be held liable. This looks like it captures them on any release and makes them liable. I think somehow that should be, you know, it looks like the finger gets pointed at the participating provider regardless of who's responsible for releasing the data.
Representative Winkler.
Mr. Chair, Representative Howe, if you would be more comfortable with correcting that language, we could do so. I'd say that from a lawyer's point of view, an interpretation of that language that would hold the provider responsible for somebody else's release of the data is kind of an absurd result and would not be used as a way to interpret this language. But if you're not comfortable with that, we could change that. And I'd be happy to work with you and Representative Holberg. This has to go to K-12 Finance. And if the language can be improved, I'd be happy to work with you on that.
Any other questions from members? Representative Howland, if you could follow up with Representative Winkler on that between now and K-12 Finance. Did I already ask for public testimony on this? Okay. Representative Winkler has moved that House File 1058 be recommended to pass and sent to the Committee on Education Finance. All in favor signify by saying aye.
Aye.
All opposed say no. Motion passes. Thank you, Representative Winkler. Representative Holberg, are you ready to go on House File 183? Representative Holberg moves that House File 183 be recommended to pass and sent to the General Register. Do you have a DE1 amendment, Representative Holberg?
Mr. Chair, I do.
Okay.
Mr. Chair, if I might move the DE1 amendment, House File 183, to get it in the shape I'd like to discuss.
Okay, Representative Holberg has made the motion. All in favor signify by saying aye. Aye. All
Aye.
opposed say no. Motion passes. To your bill as amended, Representative Holberg.
Thank you, Mr. Chair, and I'm sure there's plenty of people that want to testify on this. And the Section 1 of the bill is probably going to draw the most fire, and it's related to access by data subjects to find out who has had access to the information about them. And as it's written, it is still needs some work. We certainly, in this language here in front of you, say that undercover law enforcement officials or active investigative data, the information would not be available to the data subject, but there are other protections that probably have to be made, and the language is written is probably too cumbersome to be managed across the whole system. That being said, one of the basic precepts of good data practices policy is that an individual has the right to know what information is being collected and how it's being used. And I think there should be some accountability with the system, but I will fully admit at the onset that Section 1 needs more work. The Section 2 of the bill is asking that policies be implemented as far as access to data, and some of this comes as a result of recent stories in the news about massive access to individuals' information. What is apparent is, in many instances, a complete lack of oversight, and this bill is trying to get a handle on some of those issues. Then it also requires that Section 3 of the bill requires that if there is a breach of security, that a report be done, that the results of the report be posted. If disciplinary action was necessary, what the disciplinary action was, and if there wasn't any disciplinary action, the reason for that as well. I did have representatives in my office yesterday afternoon from labor organizations, and they raised concern about this section of the bill that there could be an appeal process guaranteed to employees, and that they are looking for language in this bill that would make sure that the release of the individual employee's name was not required until all appeal processes had been exhausted, and I agreed to that. I just haven't seen any proposed language from them yet on that particular issue. And the fifth section of the bill is a recommendation by the legislative auditor. They recently did an audit of law enforcement databases and submitted that they thought that the agencies that are submitting information to the CYBERS database be public. So not the information itself, but how many agencies are working with that particular database. And I'm happy to stand for questions, and I know there's probably a whole slew of people that want to testify.
If there are, Representative Holberg, then I think we'll take testimony before we go to questions. So the only person I have on my list is Keith Carlson, Executive Director, Minnesota Intercounty Association.
Mr. Chairman, members, I am Keith Carlson with the Minnesota Intercounty Association, and I'm also appearing on behalf of the League of Minnesota Cities and the Association of Counties, Minnesota Counties. First, I want to thank Representative Holberg for her amendment. Generally, sections 2, 3, and 4, we are in general agreement with the provisions there. And I have just seen Section 5 for the first time. I will defer to our friends in law enforcement to identify any potential concerns. As Representative Holberg indicated, we do have substantial concerns with Section 1, the new language that starts on lines well, the new language, I'm sorry, I don't have the new language that starts on lines 1.16. This is far more expansive than the issues that the committee is familiar with that exist with the Department of Public Services Driver and Vehicle Services database. This applies to every bit of private data that is administered by state and local government in Minnesota, and literally would be a nightmare for us to administer. Now, you may hear from advocates for data privacy that it does not impose any new obligations, that we are not required under the general tenets of the data practices law to create data. But I frankly ask you rhetorically, how stupid is it to create a premise that an individual can come in and ask, which of your employees have been asking for my private data, and then we turn around, yes, you can ask that, but no, we can't tell you that because we don't know, which is the truth in many instances. Many of our more antiquated systems just do not track on an employee-by-employee basis who is accessing private data. In many instances, we're still dealing with paper records, and we don't have any procedures because we are not obligated under current law to track individual employees. And let me give you several examples of that. Every piece of personnel data that we have contains private data. So every person in our human resources departments are accessing private data on a routine basis daily, literally dozens if not hundreds of times. We would have to establish procedures to log that access to really substantially comply with this. Every time people at our service counters receives an application for a driver's license renewal, a new driver's license, a motor vehicle license renewal, they are looking at private data because the name on that application under current law is private data. We have no routine procedures to log who actually accepted that data. Every individual who administers welfare, whether it's a financial worker who's determining the qualifications for the individual to receive that, or social workers who serve the specific needs, are dealing with private data, as well as our corrections officers, our public health nurses, the individuals who enforce child support collections. All of them deal with private data on a routine basis, and again, we do not have systems in place that routinely track this data. So again, I would suggest to you that this is impossible to comply with currently. To effectively comply with it will cost literally millions of dollars for state and local government to put in place the systems that will allow us to literally meet what is the so-called obligation here. With that, I'll conclude and be happy to answer any questions.
Thank you very much for your testimony, Mr. Carlson. Are there questions specifically for Mr. Carlson that members have? Representative Liebling, go ahead.
Thank you, Mr. Chair. And Mr. Carlson, frankly, your testimony kind of scares me. And maybe that was Representative Holberg's point in putting this in. I don't know. But I get your point about no systems are in place. But it makes me wonder, going forward, as we change to more, we're getting more systems that are more capable of tracking data. And I know in a lot of institutions, for example, at the Mayo Clinic, everybody who accesses a medical record, there is a tracking on that. So that if my husband goes and accesses my record, so it will be flagged as an improper access. And somebody will, tap him on the shoulder and say, what the heck? So I just wonder if going forward, this isn't something that we should be looking at every time we update a system and go electronic and start gathering more data and making it more usable in more places. So I guess I'd like to hear your comment on that because, I do hear the point that if we were to say this, that it would be darn near impossible to do. But that's retrospectively. I wonder about going forward if we shouldn't be saying everybody's got to start building this in.
Mr. Carlson.
Mr. Chairman, Representative Liebling, I could not agree with you more, and in fact, that is what is happening right now. The focus of all the angst that has been culminated in this bill, the driver and vehicle services database. Right now, we know after the fact when our employees have been accessing the database on an unauthorized basis. The department has certain thresholds where they flag individuals, I believe it's either 50 or 100, who are making unusual levels of accesses to the database, and they send that information back to the initiating agency so they can follow up to see whether it. But the point is, we do not know at real time when those unauthorized access. The department is in the process of updating that system and hopes to be able to provide that sort of system, real-time sort of monitoring a few years down the road. I will also point out to many of our individual counties, local governments are updating their systems, particularly in the criminal justice area. But still, the technology is such that we can perhaps track the squad car that initiated a access to, again, using the driver and vehicle services database. It does not identify the individual because during each shift, the individual who is using that car changes. And in fact, if there's double staffing and that, we cannot tell, even during that shift, who was the one who accessed that. So we still are somewhat reliable on manual processes. Again, the bottom line, as we go forward, as we are upgrading our systems or creating systems where manual processes exist right now, we are putting those capabilities in place, but literally there are hundreds of types of records that we deal with where that tracking does not exist currently.
Representative Simon.
This isn't for Mr. Carlson in particular, but I just want to say, Representative Holberg, I think the best part of this bill is Section 3. I think the new definition of the data breach is much needed. It's sort of surprising that this wasn't done a while ago. So I think that's the best part, and I'm wondering whether, as to Section 1, at least in the interim, as we're gearing up towards kind of the world that Representative Liebling says that we should aspire to, where we can have the kind of Mayo-like tracking, assuming we don't have that yet, and we don't have the capability to do that yet, particularly as to all governments. I mean, maybe the state could, maybe some counties could, but Hopkins City Hall that I represent probably doesn't have the sophistication to figure out exactly which individuals touch this, and since the Data Practices Act applies to all government, what about something in Section 1, just as this bill moves forward, that is triggered by a breach, as you now newly describe it? In other words, once there's a breach, you get to find out all the people who access this. That might be one way to do it. I don't know if you'd be amenable to that, and maybe we can't figure that out today. But that might be an interim solution so that as we ramp up to the capability to track individuals, at least there's something in place. I don't know what you think about that.
Mr. Carlson.
Well, it was for Representative Holberg.
Oh, sorry,
Thank you.
Representative Holberg.
Thank you, Mr. Chair. And Representative Simon, as I said at the onset, I know this has problems, but as you heard from the testimony, I think people should be concerned about where we're at in the public sector versus the private sector. The incident at the DNR, Mr. Carlson's right, they're flagging the top 50 users on a weekly or daily basis, and that system did not flag the DNR situation, in which over 17,000 records involving over 7,000 people. So what we have in place, even, as he holds up as the example of how some of this audit is done, is woefully lacking. And I was first elected in 1998, 99. All we heard about was Y2K and how we had to upgrade everything. The world was going to come to end. I shudder to think the amount of money that we have spent on computer systems within state and local government in the 15 years that I've been here, and to find out that we're sitting here in 2013 with computer systems in the public sector that are basically working in the Stone Age related to data on individuals, of which some organizations hold some of the most highly protected and sensitive information, and we have just really not even addressed this issue in any way, shape, or form, to me is shocking. And I know, like I said at the onset, Section 1 has major problems, but I think we, as public policy makers, need to have the discussion, what level of accountability do we want to have within these systems, and what rights should individuals have to know what their government is doing with their information. Looking around the room, I'm probably going to be at one end of the spectrum. Some of you will be at another end of the spectrum. But I think as a matter of public policy, we need to start talking about this and communicating with those that are implementing our laws that this is important.
Mr. Simon.
Just to follow up, and I knew you and I have talked about this before, we need to strike the right balance here. I think your bill goes a long way towards striking it. Government is in a tough spot in Minnesota with our Data Practices Act because they get penalties if they disclose too much, and they also get penalties if they disclose too little. And look, I'm the one I carried the bill to increase the penalty from $10,000 to $15,000 per incident, so I'm not a softie on that. But that's pretty severe, but I appreciate their dilemma. They get sued if they release stuff, and then if they hold on to stuff that somebody in the public says they have the right to, they also get sued. So they are also, at all levels of government, trying to find the right balance. If they disclose too much, someone's mad at them. If they keep stuff back, someone else is mad at them. And I appreciate particularly in Section 3 that you're trying to strike that balance.
Representative Winkler.
Thank you, Mr. Chair. Representative Holberg, and this is to Mr. Carlson's comments. As I read Section 1, I guess my question to you is there any obligation to have real-time access if they don't know who has obtained access to those records? Obviously, they can't provide the information. This doesn't necessarily assume a huge new burden. And just my other general comment is, our job is to set standards for people to meet. We do that in all sorts of ways. It is not exactly on point, but we set a renewable energy standard and expect industry to figure out a way to do it. I think we have to set a very high standard on data privacy and data protection for government at all levels and expect them to figure out a way to meet it, because we do it in the medical sector, and it's not just the Mayo Clinic who has that system. My mother works at the hospital in Bemidji, not exactly a destination medical center unless you live in northwestern Minnesota, and they have the same system. The medical industry has figured it out because the government has demanded it, and I don't see that this is in any way different. So, just to the way that Section 1 would work, I wonder if you could describe your intention as to what the obligations are of government entities to provide this information.
Representative Holberg.
Thank you, Mr. Chair, and you're right. To the extent that data doesn't exist, you can't be required to disclose it. But they make a fair point. It's for the local entities. This is breathtaking in its scope. If they interpret it that you would have to be able to provide that information. But again, I just want to be very clear that it needs additional work. I would look to the members of this committee to provide some feedback as to where they think we should go around the public policy around this issue. And I think there's probably more people that want to testify against it as well.
Okay, are there any other questions specifically for Mr. Carlson? Representative Howe, yours is specifically for Mr. Carlson.
Yes, thank you, Mr. Chair. And Mr. Carlson, I entered the fire marshal's office back in 1992, and everything was paper back in our files, tracking all the buildings and all the tenants in all these buildings and exactly what orders we wrote on them. And we were required, and I look at this thing and I go, we had to take a little out file and write out who had the file, and we slid it in there when that file came out. I don't see that tracking those people going into that file would be any more difficult if they're in an antiquated system that I entered back in 1992 as that. So you could have a little red file that says out that slides in there. Would that not comply with the intent of this current bill?
Mr. Chairman, Representative, yes, it would in the case of existing files. But again, the mere receipt of an application, such as a driver's license renewal, a motor vehicle license renewal, that name on that application is private data under current law. The only tracking that I think many service counters do is basically the cash register to process the payment that accompanies that, unless the individual has to, basically generate a bill for an individual who shows up without his or her statement from the Department of Public Safety. Again, there are thousands of documents that we process, whether we're cities, counties, school districts, or the state every day, where there's not logging at the front end like that. And again, the problems that are created by the basic tenet of the data privacy law that everything is public, but, for example, generally a name of an individual would be public, but again, the exception is on a driver's or vehicle license renewal, the name of an individual is private. We would have to go, we certainly train our employees of that, but we have not created the logging that would be required to do that. And it goes beyond just saying who's accessing a file. It would be saying who processed this particular application. We do not have that logging. We don't have automated processes to do that right now.
Representative Howell.
Thank you, Mr. Chair. Mr. Carlson, I find that a little hard to believe just on the financial tracking because they're going to get a payment, and I'd have to believe just to make sure that the dollars don't disappear, that they know who took that transaction and where that money went, who's operating the till at the time that came through. So I appreciate your input, but I just can't believe that those things aren't in place at the current time. Thank you.
Representative Uso, is your question for Mr. Carlson specifically?
Yes.
Okay, go ahead.
Thank you, Mr. Chair. Mr. Carlson, I'm wondering if the language on, it's on line 1.17, where it says an individual has access to the name of persons who have obtained access. If that said instead who may have obtained access, would that give enough wiggle room to the small entities that don't have sophisticated computer tracking of who's logging something, and at the same time provide some incentive for organizations to kind of get their data under control?
Mr. Carlson.
Mr. Chairman, Representative, yes, that would be helpful, but the result of that would be to the extent that the local government has a service counter where they perform deputy register functions, they would basically say every employee in that department possibly accessed your department. If you happen to be a homeowner or any property owner, frankly, we would say everybody in our property records department would possibly have had access to that data, and so on and so on. I'm not sure it really meets the objective of being able to identify the specific individual. What it does tell the people is what they probably already know, is that government is accessing private data on a routine basis, and that a number of employees within that entity may on some point in time have access to record for that individual.
Representative Uso.
Thank you, Mr. Chair. I was thinking that it would provide a little bit of incentive, at least for local governments and whoever, to kind of get their processes under control, so that if they have a request of who has access, they would actually be able to say that we kept this in this locked file cabinet, or these people had access and not, the entire building. Do you think that would be helpful?
Mr. Carlson.
Mr. Chairman, yeah, I don't dispute that it creates the incentive, but it will cost money, substantial money, to set up those processes that do not exist currently, either in new or improvements to existing software, possibly automating what are currently manual processes, or creating the logs, which will take time, both in creating them and then providing that the individual logs each access to the particular records every time he or she accesses it.
Are there other members of the audience who would like to be heard and testify on House File 183 as amended?
And Mr. Chair, if I might, we heard about all of the
I'm
costs of complying with this type
Mr.
of
Carlson,
policy.
don't go anywhere for a second. Representative Scott has a question for you. I'm sorry, say that again,
I'm
Representative Holberg.
sorry. We heard about all the costs to local government, et cetera, and I'm not disputing that compliance would have some costs, but I think that in the next year or so, it's going to be staggering the amount of costs to local governments that's going to be paid out relative to some of the breaches that have occurred.
Thank you. Representative Scott.
Thank you, Mr. Chair. Mr. Carlson, I seem to recollect, and my first term I was on the Transportation Committee, and it seems to me that DPS was investing a significant amount of money to update their systems. And why in the world would they not have put something in as simple and as usual as just typing something in to say that I'm the person using this station?
Mr. Carlson.
Madam Chair, the representative of the department is right here. I'll
Oh.
just tell you that they're in the process of upgrading the system right now. It's a 4-year process. The system will not totally be up until.
Thank you.
Mr.
Please
Chair.
introduce yourself for the record.
For the record, my name is Mary Ellison. I'm Deputy Commissioner of the Department of Public Safety. We have, in response to your question, Representative, we know who accesses our data, and we flag potential misuse, and we let the local unit of government know that they should investigate that and take appropriate action. So I feel compelled to testify. Now, my testimony is specifically about the driver and vehicle information system, which is the subject that and cybers, which is operated by the BCA, of the legislative auditor's report. So we know we have user agreements with people who access the DBS system. We know who's accessing it, who they're accessing. We have all of that information. The frustration that I have, and why I felt compelled to talk, is that so much of this is about management of your employees that have access to the system. I have been Deputy Commissioner of the Department of Public Safety since 2004. And we have been ringing the bells and ringing the chimes with our partners to say, don't use this data system for anything other than official duties. And when people sign in to the system, when they have access to it and have a user agreement with us, they have to check a box that says, I am certifying that I'm only accessing this information for my official duties. So, and still, we have people that misuse the system. And let me talk just a little bit about the Department of Natural Resources person. Representative Holberg is correct. We did not flag that person. And perhaps shame on us. He was a high user, but this person was a law enforcement officer who was in charge of data practices and data practices training for his officers in the Department of Natural Resources. So in putting this in context, I think it was reasonable to assume that this person would be carrying out his official duties in a responsible manner. So again, you can hear a little frustration in my voice. I think we tend to focus on the systems, and why can't we track everything through the systems? We can track who's accessed. We know who's accessed. We tell local units of government all the time, train your employees, manage your employees, have proper oversight of your employees. There's only so much that we can do. And when a law enforcement officer has access to that data by the nature of his or her job, we cannot look over their shoulder every time they access it and make sure they're not accessing something inappropriately. That's up to the local unit of government. So we can go down the path of this is going to cost $1 gazillion to implement all these systems, and that's true, but this largely is about good management. So I appreciate you listening to my diatribe, and I'll stand for any questions.
Thank you. Questions, members of the committee. Representative Scott.
Just a follow-up, and I'm really glad to hear that the system is capable of doing that. And, I'm hoping that because of what happened recently and the OLA's report, I'm hoping that will start to change the culture within our government agencies so that management is a little bit easier, management of these people is a little bit easier, the people that have access to this data. And I just want to go on record here. I was one of those people who was accessed by this DNR individual. And if there's a class action lawsuit out there, I don't care if I get a penny, but sign me up.
Mr. Chair, Representative Carlson.
Representative Scott?
Just more of a comment.
Okay, thank you. Questions from members of the committee? Okay, thank you for your testimony, Ms. Ellison. Any other testifiers on the bill? Ms. Frazier. Please introduce yourself for the committee and begin your testimony.
Thank you, Mr. Chair and members. Beth Fraser from the Office of the Secretary of State. And I am not here about elections, just to be clear. I am here because our office runs, do you have the early voting amendment, Winkler? Oh, sorry. I am here because the office runs a address confidentiality program called Safe at Home. And it is a program primarily for survivors of domestic violence, but also includes some people who are in the program for professional reasons, prosecutors, people in law enforcement. And the program is for people who are in very dangerous situations and is based upon programs in many other states. And in some of those other states, the staff of the program have actually been stalked themselves because they're some of the few people in the world that know how to find the participants in the program itself. So we have gone to extraordinary lengths to protect both the data, the participants, and our staff. And we're very worried about this language that would allow somebody to know who has accessed private data, because all of the data on all of the participants is, by definition, private data. And if somebody was trying to find out more information about the staff of the program, they could apply for the program. Even data on an applicant is private data. So if they applied for the program, even if their application was deficient and they weren't accepted, they could then say, oh, and I want information on who's seen my data, which would then give them the list of the staff members, which we have gone to lengths to protect. And so we would like to see an exemption for members of the staff of this program. So I have spoken to Representative Holberg about this previously, and am hopeful that this would be a friendly amendment. And I'm happy to answer any questions.
Thank you for your testimony, Ms. Fraser. Are there questions for Ms. Fraser? Okay. Okay. Anyone else from the public who would wish to be heard on House File 183 as amended?
And if there's
Representative
another
Holberg?
gentleman coming down here, but Ms. Fraser's comments, certainly we've worked over the years on this issue, and she's been very busy this year trying to get special language in a number of bills. And in fact, I had a conversation with Mr. Gehring yesterday and said, why doesn't her language apply? And so we're going to take a peek and see if we have to beef up the safe at home language so she's not running around all the time trying to get special language in the MnDOT bill and the Met Council bill. And she's got better things to do than to chase us around day after day on all these individual bills.
Thank you. Please introduce yourself for the record and begin your testimony.
Thank you, Mr. Chair. I'm Dave Picha, Executive Director of the Minnesota Chiefs of Police Association. I'd just like to testify on two sections of this bill, specifically Section 1, Subdivision B, 1.16. Our members are concerned in that from a safety perspective for law enforcement officers that may run somebody legitimately, and that individual thinking that they're a suspect in a crime, then want to find out who ran them and why, and then perhaps it could be a safety issue for the officer. What we have done, and Representative Holberg was gracious enough to meet with us on more than one occasion to talk about remedy for this situation, would be the creation of a task force that would include members of DPS, the Chiefs Association, Sheriff's Association, MPPOA, County Attorneys Association, and the Post Board to specifically deal with the issues in the Legislative Auditor's report, but also to deal with the issues that this language is attempting to get at. And we're confident that we'll be able to continue to have those conversations with Representative Holberg and therefore resolve our issues with this section. On section number 5, line 6.12, where it talks about the cybers data, our members are concerned that there's limited use of the cybers data at this point, and that this provision might be the straw that breaks the camel's back, in that it's one additional report to then access or use cyber's data. So that, with that concern, we would again like to work with Representative Holberg on the language and the intent, and to hopefully resolve this issue very soon.
Thank you very much for your testimony, Mr. Picha. Others members of the public who wish to be heard on this, then none, I'll open it up to questions from members of the committee in general for Representative Holberg. Comments, questions from members?
And Mr. Chair, they did provide a draft of a working study group, and as much as I detest them, we might end up going there on Section 1, but I do want to have the conversation about the public policy as well.
Representative Winkler.
Thank you, Mr. Chair. Members just got an A2 amendment. This is what Representative Holberg talked about, and this is obviously not within the 24-hour rule, but she talked at the beginning about making sure that we follow the due process for public employees. She has now seen the language. She gave me a head nod when she read it, indicating that she thought it was fine. And obviously, we have, this came in late, but if members are okay with it, I'd like to move the A2 amendment to take care of what I think is a very fair point, which is you shouldn't release data about an employee unless there's actually been a formal disciplinary action after all the steps have been followed.
Questions from members about the A2 amendment? We all have that, members. In light of the conversation, members, it is not normally my practice to work this way, but it is deadlines, and so if there's no objection, I will allow the A2 amendment. All in favor signify by
Mr.
saying
Chair?
Representative Holberg.
I don't know if there's anybody in opposition, but maybe we should just ask, given its late introduction. And
Is there anyone in opposition to the A2 amendment?
I just want to know if I would be taking on more water.
All in favor signify by saying aye.
Aye.
All opposed say no.
No.
Motion passes. Thank you. So to your bill as amended, Representative Holberg, unless there are any other questions from members of the committee, any wrap-up? Oh, I'm sorry, we have questions. Representative Johnson.
Mr. Chair, this is more of a comment. Representative Holberg, the intention of this bill I really believe is important. The issues we have is the difference between electronic data and paper data. In government, there's so much more paper data that even if you require signatures for somebody to look at it, if somebody's going to look at it improperly, they're not going to sign the form, so that part is never going to be discovered. So it makes it real difficult to enforce. We heard people talk about how in the hospital they can flag right away when somebody looks up their data. Unfortunately, when you fill in the hospital setting, you have no idea who looks up the paper form you fill out waiting in the waiting room. That information is not available, who looks at it, what people do with it, but that's still private data. Until we get into an all-electronic world, our tabs for our vehicles, our applications for our driver's licenses is still done on paper. And until we get in a completely electronic world, our data is going to be compromised in some way or another, whether we like it or not. How we get to the point where it's 100% protected at this point, as long as there's paper, I don't know how we can do that.
Thank you. Any other questions, comments from members? Seeing none, then Representative Holberg moves that House File 183 be recommended, as amended, be recommended to pass and sent to the General Register. All in favor signify by saying aye.
Aye.
All opposed say no. Motion passes. Thank you. Representative Holberg, to House File 474. And the motion from Representative Holberg is that it be recommended to pass and sent to the General Register. Representative Holberg has an A2 amendment.
Mr. Chair, I'd like to move the A2 amendment, which is actually a delete all as well. To get the bill in the shape I'd like to discuss.
Thank you. All in favor of the A2 delete all amendment signify by saying aye. Aye. All opposed say no. Bill has been amended. Representative Holberg, to your amended bill.
Thank you, Mr. Chair. And this bill tries to get at the issue of the license plate reader, new technology that's being used. We don't know in how many agencies across the state. It's a technology where hundreds of license plates can be read automatically, run up against various databases to see what hits there are, if you will, and locate people and vehicles that law enforcement has an interest in finding. There's definitely privacy concerns around this issue. License plate readers have been used for a number of years. It's one of these frustrating issues where they knew they had data issues around it, but rather than come to the legislature and have the discussion before they start using the technology. They start using it, then the information, of course, is all public. We had stories in the last year or so about individuals going to get runs of all this information and using it for a variety of purposes. That then prompted the city of Minneapolis to go for a temporary classification with iPad, Department of Administration. That ruling, I believe, was released yesterday or the evening before. The Minneapolis, and in December the decision was made that that ruling would apply statewide to all license plate readers, all agencies using them, and City of Minneapolis asked for a variety of data sets to be classified private or confidential. The administration gave some of them. We're kind of in a real mess around this issue right now, and that we have a temporary classification of some of the data. We need as public policymakers to make some decisions about how this technology should be used and who should have access to what information. So that is the purpose of House File 474. One of the major sticking points is what would be commonly referred to as non-hit data, information on at least arguably law-abiding citizens who just happen to pass by or drive by one of these readers, what should happen to their information. In my bill, it's a 10-day retention. The range across the country ranges from 0 and I think unlimited, with about a third of them being 30 days or less. And so the other issue that I think there's still heartburn is on page 1, line 16, the locations at which the reader is installed or used. They're concerned about vandalism. They're concerned about the bad guys avoiding those areas, and that it's defeating the purpose. Some would say that the red light camera would be a similar technology where everybody that comes within its wake is recorded. In some states there's warnings, red light camera ahead, so that individuals have a choice whether or not they want their images captured for law enforcement purposes or not. So again, that's a policy decision that we need to discuss.
Thank you, Representative Holberg. Are there, before we go to questions, unless there are just initial questions for Representative Holberg, I'd like to go to public testimony on this. We've only got 20 minutes left in this committee session. Please come down. Who's on the list? Oh, Representative Newberger, do you have a question specifically before we went to members of the public?
I do. Just how common are these?
Representative Holberg.
Well, Mr. Chair, again, we don't know because we don't know how many jurisdictions have them. That's kind of one of the problems with these, but they're becoming more and more popular and more quote-unquote cost-effective. So I think that I'm guessing the number being used in the state of Minnesota will not be going down anytime soon.
In order to better manage the committee's time, I'm going to ask that if you want to testify on this bill, you're a member of the public, please come down and stand where the officers are standing right here now. So I've got 4 so far. So we're going to have 4 testifiers. Please take a seat, introduce yourself for the record.
Thank you, Mr. Chair. Good morning. Good morning, members of the committee. My name is Ken Reed. I'm with the St. Paul Police Department. The St. Paul Police Department first implemented mobile license plate readers in 2008. We have found license plate readers to be an invaluable public safety tool. Since implementation, we've used, I'll refer to them as A.L.P.Rs. That's commonly how they're called. We've recovered over 1,072 stolen automobiles, located missing persons, and the data from these has provided invaluable leads for solving violent crimes, including helping to locate evidence and suspects in 2 separate 2012 murder investigations. If I may just briefly kind of give a description, because I think it's helpful that people understand how the technology works. Ours are mobile. They're two cameras mounted on a squad car, infrared and regular photography, And as the officers driving down the street, they are calibrated to capture the license plates of any passing motor vehicles, the license plates. That takes that and transfers it into a text file through optical character recognition, and then that text file, the processing unit, reaches up to a compiled file of state and federal license plate related information, and then makes a comparison. If it matches or makes a hit, then it notifies the officer that there was a hit, and I'll explain to you which data files that would relate to, and then the officer can take whatever appropriate action. In Minnesota, the license plate readers, once that comparison is to these following files: the FBI stolen license plate files, the wanted person files, the Canadian Police Information Center, which is also stolen motor vehicle files, protection orders, missing persons, violent gang and terrorist organization, supervised release files, convictor sexual offender registry, and immigrator violator files. Minnesota data that is added into this compiled file set is the Keep Our Police Safe files, which are warnings to officers, Minnesota warrants, and also suspended, revoked, canceled, and disqualified driver's licenses. In addition, because it is text file based, many localities use it for their scofflaw, or for those unfamiliar with that term, it's parking violators that have over a specified number of parking violations. It is important to note that the data captured by the A.L.P.R. systems is data that can be gained by any person, as the vehicle license plates and their locations are publicly accessible and in plain view. In other words, the officer is rightfully in a position to observe the license plate, and therefore they can be captured without need for authorization, and those observations are admissible as evidence. One of the reasons Minnesota requires a front and rear license plate and requires that the license plate not be obstructed by dirt, debris, or snow is so that law enforcement can identify the vehicle by its license plate and see that it is properly registered, and if necessary, make further inquiry. This is all information that is readily and legally available to officers. In fact, good officers and investigators make notes and lists of vehicles stopping and passing by locations when they're monitoring criminal activity all the time, without and with technology. A.L.P.R. technology is simply a modern, efficient means to capture data that is already publicly available to an officer through his or her own primary senses and their own monitoring. The courts have upheld in other contexts the use of technology that enhances an officer's primary senses as long as it doesn't enter into protected areas. License plates on vehicles in public areas are clearly not in protected areas. In fact, a very recent 11th Circuit Court of Appeals decision about A.L.P.R., the court noted that visual surveillance of a vehicle in plain view does not constitute an unreasonable search for Fourth Amendment purposes. Why am I here, and why do I feel strongly about this? We have some problems with the language in 1.10 to 1.13 in the delete all. It's language limiting to which data, for example, that we can use. I gave you the example of scofflaw data in comparison in those captures. If someone was to challenge that in court with the limiting language, we would not be able to provide that as evidence when it was being contested. That's just one example. And the other reason is, other than my earlier comments, you're going to need to consider this, please. In a 2012 St. Paul murder case, the murder was committed 9 days after the suspect's license plate was read and captured into the A.L.P.R. data. It wasn't until 35 days after the murder that investigators received information which caused them to look at the data for this case to locate the suspect and prove that in the past the suspect vehicle had been parked at the address of two other additional suspects, providing evidence of complicity. A.L.P.R. data helped locate the murder suspect vehicle in a different 2012 murder case within 2 days, which resulted in the arrest of the suspect. In yet another case, a violent gang member's license plate was read and captured by the A.L.P.R. 8 days before he committed a violent assault. 13 days later, a query of the A.L.P.R. data aided in the arrest and charging of this violent individual who had a long history involving illegal firearms. These are the reasons why we support the classification of data as contained in this bill. We've recommended a retention period of at least 180 days, and we do want to talk more about the limiting language in this current amendment. We don't want to settle. Law enforcement does not want to settle for good enough is good enough. This technology is just an enhancement to an officer's own senses and monitoring capabilities, and when it comes to reducing violence, making use of new technology to do more efficiently what we already do makes sense to us, and we hope it makes sense to you, Mr. Chair, and members of the committee.
Thank you, Commander Reed. Questions for Commander Reed specifically? I have a question, Commander Reed.
Yes, sir.
When officers use existing technology to determine the location of my license plate driving down, say, Rice Street, is that information subsequently searchable?
If we're using the, Mr. Chair, if we're referring to the A.L.P.R.?
No,
Okay.
not using that.
Okay.
But if an officer is behind me on Rice Street at Maryland and queries my license plate number to determine whether it's going to come back stolen or the registered owner is revoked or what have you, is that information subsequently searchable, whereby someone under this bill 9 days from now could determine my location and where I was?
In just a general sense, if he's doing it out of, for some reason, your vehicle caught his attention, they would run it. It would run it through the state systems, and that, from the previous bill, the ability to find out who and when were run is available, as I understand it, yes.
What about the location, Commander Reed?
The location would not necessarily be available, no.
Okay, thank you. Next testifier. Please take your seat and state your name for the record, noting we have about 11 minutes, so please keep your comments restricted to the portions of the bill that you have concerns with.
Good morning, Mr. Chair. My name is Inspector Rob Allen. I'm with the Ramsey County Sheriff's Office. Like me, automated license plate readers are relatively new to Ramsey County. A few of our suburban agencies have readers already, and the Ramsey County Sheriff's Office will be investing in A.L.P.R. devices for our use and the use of our partner agencies. The A.L.P.R. devices are being funded through auto theft prevention grants, and that makes sense because the A.L.P.R. devices are very effective at scanning license plates and running them against a hot file of known stolen vehicles, which is maintained by the state's Department of Public Safety. The system, by automatically scanning license plates, allows our deputies to focus on other things while patrolling, and then be alerted if a car that has been reported stolen, or if a car is owned by a wanted felon is driving by, or if a car owned by a registered sex offender is operating in a school zone. While the live scanning of plates is a tremendous tool for law enforcement, we are being short-sighted if we don't also recognize the value of using stored information about scanned plates as an investigative tool. There's often a significant time lag between when a car is stolen, for example, and when the theft is detected and when the report is made. Since the A.L.P.R. stores data on license plate scans, it allows an investigator to see where a stolen car was parked, even though at the time the plate was scanned, the car had not yet been reported stolen. In my prior position as a deputy chief in the Minneapolis Police Department, we had several incidents in which stored data helped us with critical investigations. In a homicide case, for instance, there may be very significant time delay between the time the crime is committed and the suspects are identified. Once suspects are identified, there may be a significant lag in identifying what vehicle the suspects were driving at the time of the incident. One case in point is the homicide of a 13-year-old boy in North Minneapolis. It took us several months for the investigators in that case to identify the vehicle that the suspect used. According to the commander of the homicide unit, A.L.P.R. data retrieved 3 months after the incident was part of the evidence that helped secure guilty pleas from the 3 individuals in that case. In another case that remains open, the victim of a homicide was not discovered for more than a week after the crime had been committed. Stored A.L.P.R. data in that case helped homicide investigators identify a person of interest in that case as well. Stored A.L.P.R. data also helped identify a suspect in a very serious case of stalking by showing the suspect's long history of driving by the home of the victim who had received an order for protection against the victim. It is important to recognize the significant value of stored A.L.P.R. data as well as live scanning of license plates as a tool that will help solve crimes and reduce crimes in the future. It is also important to address some of the misconceptions about A.L.P.R. A.L.P.R. does not keep track of where people have been. It stores no personally identifiable information, only the license plate number, date, time, and location where the scan was made. In order to see to whom a car belonged, the officer still has to query the state DVS records, for which there is an audit protocol in place. A.L.P.R. systems also have an even tighter controls over who can do the queries. In Minneapolis, for example, queries of A.L.P.R. data can only be done in the strategic information centers by officers who have received extensive training in 28 CFR Part 23 and Chapter 13 of the Minnesota statutes, which cover the rules of data privacy. I also want to address the importance of keeping locations of the readers secret. Let me give you an example. We've had instances where we've had very specific, credible threats against high-profile individuals. In order to reduce the amount of staffing that is needed to protect that area, we use A.L.P.R. data or A.L.P.R. readers looking for very specific vehicles to cover some of the intersections that would lead to that specific target. If we were to have to announce where we were using A.L.P.R. readers, we would be unable to protect the target as easily because the bad guys would know there's A.L.P.R. here. We'll have to go this other way. I urge the committee to allow law enforcement to maintain access to this powerful tool and to protect the stored data from becoming public data, which might be used to stalk or harass victims. Thank you for your consideration.
Thank you, Inspector Allen. Next testifier. Liebling, did you have a question specifically for Inspector Allen?
I do.
Noting that we have 6 minutes left, please be.
Yeah, thank you, Mr. Chair, and because of that, I won't add an editorial comment. But my question is it your position that because this data can sometimes be very useful for solving a crime, that there should be no limits placed on it?
Inspector Allen.
Mr. Chair, Representative, that's not my position. I think it's appropriate to put limits on it, and I think the 180-day limit is satisfactory. When we first implemented A.L.P.R., we looked at other states and what their data retention practices were, and the state at that time, the majority of them were retaining data for 5 years. And that's certainly not what we're seeking, but I think that 180 days is reasonable for storage of that data.
Next testifier, please take a seat and state your name for the record.
Thank you, Mr. Chair, members of the committee. I'm Dave Peach, Executive Director, Minnesota Chiefs of Police Association. I'll just address two issues relative to the bill. One is we do support that the data is private. As the previous testifier mentioned, we do support a 180-day retention period. Jurisdictions vary widely in their A.L.P.R. data retention policies. The United Kingdom stores national A.L.P.R. data for a period of 5 years. Canada retains hits for 2 years, but limits retention of non-hits to no more than 90 days. New Jersey allows retention of L.P.R. data for 5 years. Los Angeles County Sheriff's Office allows the data to be stored for 5 years. Law enforcement agencies throughout the Washington, D.C. region show similar diversity in that their retention schedules go from 30 days to 3 years, while the state of Maine retains the data for 21 days. Our recommendation is 180 days based on the testimony of the testimonies of the previous law enforcement officials, in that they were able to show examples of why that 180 days is important. For example, in the city of Bloomington, they had L.P.R. data was instrumental in solving the crime where the individual was dropping debris off of bridges. They were able to research the L.P.R. data, and some 64 days later, they were able to put the suspect in the area of the bridge where he dropped the debris and injured and driver and caused a substantial amount of property damage. In Duluth, the L.P.R. data was used to resolve a kidnapping case That was after 24 hours, they were able to identify the vehicle involved, and were able to pursue federal charges using that. Olmsted County Sheriff's Office was able to use the A.L.P.R data to solve a metal theft case, and that information was resolved 30 days after the actual theft by using that data. So these are examples why we recommend the retention of that data being 180 days. We did negotiate 90 days with the Senate bill, and we're interested in speaking with Representative Holberg on future occasions in discussing the retention period. Thank you.
Thank you very much for your testimony, Mr. Picha. Ms. Frazier, please take a seat and introduce yourself for the record.
Thank you, Mr. Chair and members. Again, Beth Fraser from the Office of the Secretary of State, and we are very, very supportive of this bill and think it's critical that this data be made private. It is very worrisome that this data is currently public and that we don't even know which communities are using this, gathering this type of data. As an office that runs an address confidentiality program for people who are in great fear for their safety. We appreciate that Representative Holberg has limited the retention of the data for 10 days for people or for license plates where there is not a hit, but are still worried about the retention of data for participants in the Safe at Home Address Confidentiality Program for even that long. Unfortunately, some of the people that program participants fear are in law enforcement. And, we would prefer that if a program participant submits a written request, that their data be destroyed immediately if there is not a hit. And so we would love to see an amendment to that effect for participants in the Safe at Home Address Confidentiality Program. So I'd be happy to answer any questions and appreciate your time.
Thank you for your testimony, Ms. Frazier. Members, we are at the end of our committee time. It's the intention of the chair to lay this bill over until this evening's committee time. That said, it is the intention of the chair to offer at that time an amendment to this effect on lines 1.9, striking the words "must be" at the end, and on line 1.10, striking the words "destroyed within 10 days of collection of the data," and inserting the words "must not be retained in any format." That would make the retention time 0, that if you are an innocent actor, there is no reason whatsoever for the government to be tracking you in any way. So putting committee members on notice of that. Representative Holberg, did you want to make any comments prior to when we return this evening?
Mr. Chair, other than I'm assuming you'll have some visitors coming to look for you today.
They can find me by my license plate, Representative Holberg.
All right, thank you, Mr. Chair.
We are reconvening in 300 South at 6 p.m. tonight. Thank you. The committee is in recess.